Welcome to Yidala.com. It's good to be here again. My name is RavBaruc Waldman. This is the second of a third-part series on divorce. I call it a three-part series because I'm three different people rolled up into one. I'm a Rav, I'm a divorce attorney, and I'm also a mechanech. And before I forget, I just wish to inform everyone that I am located in the Monsey, New Hempstead area, and my phone number is area code 845-426-3210. People ask me, are there more divorces now than ever before? Well, there certainly are more, but remember there are also more marriages than ever before. So the real question is, percent-wise, is there a greater percentage of couples whose marriage ends in divorce than before? And unfortunately the answer is yes. While we're still way behind the non-Jewish societal percentage of divorce, even what we have is more than it should be. When people walk into my office seeking a divorce, the first question I ask them is, have you tried counseling, therapy, rabbanim, shalom bayis? One should not jump into a divorce. The impact is horrible. It's devastating, especially upon the children. And if the divorce is handled improperly, even though at the time maybe the person may have thought this would be the right way to go, the results can be devastating down the road. What do I mean? The fact is that the greatest number of complaints filed with the appellate division against attorneys are filed against divorce attorneys. Because at the time, they come into the lawyer's office, and the lawyer says, yes, I'll drain every drop of blood out of him. Or the reverse, I'll hide every single asset that you have, she'll never get a penny. And it sounds great until the fighting begins. And then the tab begins to roll. A divorce is a contested divorce, meaning where either one of the two does not want to get divorced, or they cannot agree on the terms, be it visitation, custody, distribution of assets. These are things that can run the tab starting at $20,000 into the hundreds and hundreds of thousands of dollars in legal fees. Remember, attorneys charge by the hour. You're paying for our time. Our time is valuable. If we produce a simple document, to you it may seem simple. It's 2-3 pages. It may have taken us 2 hours to write. I know I, for example, sweat over every comma, over every colon, every period, to make sure that the sentences are exact. And if I want them to be specific, they have to be very specific. If I want them not to be specific, they have to be very non-specific. But these things take time, and they take energies, and they take strength, and they sap everything out of you. I always encourage my clients to settle. It's very rare that I ever go to trial on an entire divorce, perhaps parts of one, but an entire divorce, rarely. When a couple approaches divorce, when they've tried everything and they see it's just not going to work, there are various alternatives. One alternative is to go to a mediator. It's inexpensive. You're not bound by the mediator's decision. The mediator will hear each side and try and sort out the issues and arrive at some sort of a mutually agreeable solution. That can only work, though, if when the parties walk in, they're not that far apart. I've had a couple just the other night. They sat here in this office, and everything seemed fine, and all of a sudden one thing blew up, and then the next thing blew up, and after wasting an hour with them, I said, you're much too far apart. The second alternative is what we call arbitration, or in our society that would mean going to Beis Din, having a din Torah. There are two forms of din Torah. One is called Zabla. Zabla is when each party picks one dayan, one judge, who is also representing his or her interest, and the two dayanim pick a third. That's also very expensive, and it can get very nasty. The other alternative in Beis Din, which is the more recognized and more acceptable approach, is going to a sitting Beis Din, meaning that there is a Beis Din of 3 judges who sit and hear out the issues. They will make the parties sign what's called a shtar birurun, which is basically you are undertaking to agree to these rabbis as arbitrators, and under the Article 75 of the CPLR, their decision is binding arbitration as any other arbitrator, and one must follow them. They will hear the arguments, they will come to a decision. I advise the listening audience to be very careful as to which Beis Din you choose. I'm not going to comment on any particular Beis Din, but there are some who have reputations for being pro-women, others for being pro-men. There could be a number of factors that you would want to take into consideration. Just like you would shop for a car, you would try different dealers and different models. When you shop for a Beis Din, Don't think that all bate din are the same. They're not. Do your homework. The other alternative is to go straight to court. We Orthodox Jews know that we're forbidden to do so. The halacha requires us, it's this week's Sedrus, Pashas Mishpatim, Asher Tosem Lifneim, you must bring your disputes to a Bezdin and not to the Goyish courts. Sometimes the Bezdin will allow the parties to take matters to court. For example, enforcement of child support. The Bezdin will allow the aggrieved party to take the other one to family court to take care of, to be able to distribute the monies for child support, since Bezdin does not have the power to do so, and the courts are acting within proper parameters. Oftentimes, people are afraid that the halakhic rulings will not match what the courts would come up with, and that can play out in a number of ways. I found from experience that child support, Bezdin will often award more child support than the courts would, but again, that's not always the case. Parties have the option, after Bezdin gives a ruling and they go to court, that they can modify. In other words, they can opt out of the state laws to conform with the findings of Bezdin. More often, I will receive calls from a Bezdin to ask me what would the statutory figures be, and then Bezdin will fashion its ruling around those numbers. But Bezdin usually hits the nail on the head, and it's certainly the way to go. That being the case, in many of my divorce cases come to me after they've been to Bezdin. So for me, it's just a matter of filling out the paperwork and doing the legal work. Other times it's not. Other times there's more to be done. In shopping for an attorney, watch out for the attorney who sounds like he's more interested in filling his pockets than helping you. He may tell you it's to your benefit, but it's not. I'm saying people who have hired these high-priced attorneys usually tend to regret it down the road. And more of the big law firms that are famous for aggressive prosecution of divorces, in other words, for fighting for the last drop of blood, are now moving more and more towards the settlement mode rather than the fight mode. The main issues you have to consider, anyone contemplating divorce. If there's a house, you have to consider how that house is going to be divided. Many people make the mistake of believing 50-50, going to be a 50-50 split. Not in New York State. New York State operates under a principle called equitable distribution. That's not the same as equal distribution. Equitable means fair. Once upon a time, there was one demarcation. Is it a long-term marriage, which is usually 15 to 20 years or more, or is it a short-term marriage? The difference being that anything considered long-term, the courts generally did go 50-50. It avoided having to do the arithmetic. Nowadays, the courts are being more careful, and they are doing arithmetic. For example, even if a couple would be married 30 years, if the husband put down the down payment, he made all the mortgage payments, he paid almost all the bills, the odds are that he's going to get the majority of the value of the house. The wife may argue, well, I was a homemaker, it's a secondary kind of a contribution, it's not a direct contribution, and that will affect the outcome. If the mortgage was paid out of a joint bank account, then things change. Then it becomes transmuted and it does become marital property. These are very technical issues and you need a good attorney to really explain it. Again, I'm not here to offer legal advice. I cannot do that. I'm just trying to educate the public as to what goes on in a divorce. The next issue is custody. There are children. Custody could either be joint, meaning that both parents have equal legal rights to the child or children, but in most cases the children will reside with one or the other parent. Usually it's the mother, but it doesn't necessarily have to be so. The older the child is, the more say the child will have into where he or she wants to go. Sometimes one parent will insist on sole custody, or for certain other reasons, that parent must have sole custody. That will confer all legal rights to that parent. That doesn't mean that the other parent is excluded. It does not mean that the other parent is not a parent anymore. It's just that any decisions, legal decisions, only have to be made by the custodial parent. When parents share joint legal custody, they must keep in mind they must be on relatively good terms. They've got to work together. Otherwise it doesn't work. It just doesn't work. And it will end up again in court. What I have done, I remember I once had a case where the wife was insistent that she have sole legal custody. She really wasn't entitled to it, but that was a deal breaker. And this divorce had been schlepping for 2.5 years. Even though the other attorney was also a phenomenal attorney and a tzaddik and a really wonderful person to work with, we couldn't get through to the wife to ease up on that. So I said, fine, you want to have sole custody, but I have the right to reserve certain rights to the father. In other words, yes, she has sole legal custody, but the father will have decision-making regarding education and regarding upbringing, regarding religion, and a vast number of things. So the bottom line was, the only difference between sole, legal, and joint in that particular case was that if, heaven forbid, the child needed an operation, she didn't have to wait for the husband to co-sign on the papers, and that was about it. So there is latitude. So any one parent shouldn't feel necessarily cut out of the legal rights of a child simply by granting sole legal custody to the other parent. There are ways to deal with it. Then there's the issue of visitation. And there are big differences if the two parents live in close proximity, if they don't, how the schedule should work. Usually the attorneys will work out something fair alternating. For example, father will have the first 2 days of Sukkot and the last 2 days of Pesach, and the next year it'll be switched around. Sometimes there are other factors that play out. I, for example, prefer that the boys go to the father for Rosh Hashanah and Yom Kippur, and the trade-off for that would be Shavuos. And the girls, vice versa. The girls should be by the mother for Rosh Hashanah Yom Kippur for practical purposes. What's a girl going to do with her father when he has to be in shul all day Rosh Hashanah? And vice versa. What would the son be doing with the mother? So there's a certain amount of seichel that has to go into these types of agreements. Child support. There are laws in New York State called the CSSA, which governs how much child support should be paid depending on how many children. It is a percentage of the non-custodial parent, the one that the children do not reside with. It's a percentage, 17% of gross income, 17% for one child, 25% for two, 29% for three, etc. Unless the parents are very low income, then it's a much smaller fixed amount. Again, there is a certain degree of latitude where the parties, the husband and wife, can pick different numbers. It works easily if the non-custodial parent is paying more, there's no problem. If he's paying less, then usually you would want to put, if it's very far off the percentages, you would want to include in the stipulation why that is so. Many times it could be because the non-custodial parent is paying tuition and a number of other expenses, and therefore the courts will overlook it. If it's grossly unfair, the New York courts have created an exception to the rules of arbitration. Generally, any agreement reached by the parties, in anything, not just matrimonial, business and anything at all, the courts respect whatever agreements parties come to. The one exception is regarding child support. It was a famous case, it actually involved a bezdin, where a woman was obviously forced to concede everything in order to have a get. And then she took it to court, and the court said, this is totally unfair. We see what's going on here. And they said that while the parties can make agreements, the courts have the last word. There are some courts, very few, that actually will say that the parties can't even make agreements on them. They're not valid. But the general consensus in the courts today is, make your agreement, but just remember that it's not final until we say so. Child support generally is paid directly to the other spouse. Now, before I get into that, I just want to explain something to you about the rationale of child support. And I'll give it to you with an example. Picture the scenario. You have a husband and wife. He's earning $60,000 a year. The wife is earning $40,000. And there are 2 children. That means the child support is 25%. And the father is the non-custodial parent. So there are 2 ways to look at how do you calculate